Okay, so this video we're going to be talking about topic 7, ethical and legal implications of information systems. So a couple things we're going to be talking about, information systems ethics, and code of ethics, advantages and disadvantages thereof, um, some of the concepts around intellectual property protections like copyright, patent, trademark, and then some of the challenges that technology has really brought forward, if with some of these concepts of intellectual property. Okay, so some definitions here. So the definition, information systems ethics. So if we look here under this on this link here, skill set, professional ethics, legal issues. Some of the definitions we have around ethics is, moral principles of conduct guiding individual or group behavior. Um, Obviously, ethics has been around a long time. You know, around the in organizations and in academic areas. But what's happened is that one of the things that's interesting is that new technology, most notably information technology, can actually create environments that were not necessarily understood or addressed within the original ethical frameworks. All right. So, say for example, if we take things like copyright, we'll talk about copyright in a minute, but the ability to illegally copy, you know, copyrighted material, download and access copyrighted material, was not really seen as stealing. However, it was very much, it very much was that, under the way the law is established. All right. You know, in addition, the ability, this is kind of a new thing, but the ability to aggregate information of from different sources to create profiles of people really reduces privacy and allows um, more is known about people without necessarily them being totally aware of it than maybe any other time before. So these are some of the big areas, especially as we're looking at this field right now, this idea of information system ethics. This is one of the two, couple of the hot areas that are big topics that we're trying to work our way through. Now, here's a kind of a high level. This is from ISC, so information, uh, which is an institute that focused on computer security. They also manage the CISSP. So this is kind of a set of guidelines that they've put out, around, what should be associated with the code of ethics. So, things like protect society, commonwealth, and infrastructure, um, acting honorably, justly, responsibly, legally, uh, growth of research by teaching and mentoring, discourage unnecessary fear and doubt, observe and abide by all contracts expressed or implied. So these are all, you know, guidelines were established by ISC Square. ISC Squared. Now, the thing about this is, the thing you want to remember is these are guidelines. All right, so these are the code of ethics that are here. Um, to be bound by this, so for example, like holders of CISSP certification, which ISC 2 uh, manages. Basically, when you in order to be certified, you have to be bound by this. But this is not necessarily enforceable by anybody who is not doesn't fall under these guidelines. I mean, obviously, these are all good things, but but the challenge becomes one of, okay, what under what auspices or under what domains these things can be used as enforceable uh, codes or rules. Another one, another area. This is under ACM, No one should use another person's computer systems without permission. Implementing systems that demean others are ethically unacceptable, and that organizational leaders, are responsible for ensuring that computer systems enhance, not degrade, quality of working life. So once again, this is with ACM. So similar, you see some similar characteristics to ISA squared. Once again, the dimensions of this, basically, where this would be applicable for, basically anything within ACM, but it's not like an enforceable rule or law that everyone is bound by. So we said about, code of ethics limitations. There is no legal authority. All right. The penalties for violation of the code, violation of group, expulsion from the group. For example, the CISSP is found to be outside the bounds of, operating outside the bounds of the code of ethics. They can be, that person could be stripped of their certification. Bigger problems, though, I guess the other challenge we run into this is that there's a lot of stuff that's not addressed in these code of ethics. How do you handle ethical issues that are popping up through, through the implementation of technology? Technology introduces new stuff, which might be beyond the bounds of what the original scope of what the code of ethics were in bound by. And then the other, finally, it's like, it may or may not reflect the morals of every member of the group. So the question is, is there, what is acceptable behavior? Is that, depending upon what circumstances somebody's in, one set of ethics could be, one code of ethics could potentially be in conflict with another one, determining, what would be considered accessible or acceptable behavior. So acceptable use policies basically defines what it should be, what is and what is not allowed for an organization to using a resource. I think we talked this a little bit in 6. So things like that would fall under acceptable uses. Borrowing someone's login ID and password prohibited. Using company assets to develop. If you're writing a book, and you're writing a book on a computer that was issued by an organization, that may or may not be permitted. Providing access for commercial purposes are not allowed. Sending out of, basically using your organization issued computer to do, to run it as a spam platform. Not good. All right. So, this basically, so the acceptable use policy really kind of establishes, as guidelines and actually becoming enforceable. So, say for example, if an individual was found to be in violation of them, then that could be held for, they can be held for some form of punishment by the organization. So intellectual property. So the concept of intellectual property has been around a while. So definitions under, as we're seeing here, property derived from works of the mind, but written to protect tangible resources from idea. All right. The idea is that you want to be, if you come up with something, you really want it to be protected. You want to be able to allow protection for people to come up with stuff, so it allows them to be creative and innovative. All right. Problem with digital technologies is that there's been a whole new generation of intellectual property claims, and it's it becomes more difficult, especially as computers are the ability to generate data, hold information. Really have kind of strained the dimensions of the domain in terms of what is intellectual property, how do you defend intellectual property. Now traditionally there's 3 intellectual property protections. So the big 3 are copyrights, patents, and trademarks. Those are the big, we talk about this stuff, these are the big 3. A copyright. So a copyright is protection given to any work that has an author. All right, so and that protection includes, who can make copies, who can make derivative works, who can perform and display publicly, and who can distribute. Um, a lot of times, what will happen is, especially with like people who write books, what will happen is a book will be developed and then will be passed over to the publisher. The publisher will hold the rights to the book because obviously the creation of the book, the printing of the book, marketing of the book, distribution of the book is an endeavor that has to be done. So what will happen is the author will write the book, will negotiate with a publisher who will basically handle all the printing and distribution of the book, and then the author will receive a payment, of a portion of the overall of the proceeds. So copyright protection, just some basic rules around copyright protection. So individual protection lasts for the life of the original author plus 70 years. Third-party protection, author, publisher, or other third-party protection lasts for 95 years from the original creation date. You don't have to, there's not, to gain copyright protection, you don't necessarily have to, go through a large complicated process. It's really, you create a original work in the United States, you fall under a U.S. copyright law. Now, if you want to take a legal action against someone who's using the work without permission, then that copyright needs to be registered, all right, in order to bring that. But by default, by simply creating a book, you're creating something in the U.S. It falls under copyright protection. Now, fair use, what fair use means that there are certain circumstances in which protected works can be used. All right, there are specific cases. So, for example, in the academic world, students have the ability to use copyright work, and cite copyright work in their research paper, in research papers. However, that work has to be cited, within, in specific guidelines or established in the academic world around, basically what you can use in terms of existing material in an academic paper. So really, the only really kind of comes into play is where this stuff will really come, fair use is pretty well accepted, when copyright holders feel like the market value is being threatened, is where this will become an issue, a legal issue. So there's 4 factors when you're looking at fair use. What is fair use? Number 1, whether the purpose of the use is for commercial or nonprofit education. What's the nature of the copyrighted work? The amount and substantiality of the portion used in relation to the copyright work as a whole. So, quoting something is one thing. Basically, taking 2/3 of it is a whole nother one. And then finally, the last piece is, the effective use upon the potential market. Does it change does it change the market for that material? Now, there's a rule. So what's happened is, there was, copyright rules been around a long time now. There was actually an extension of that put into law, extended, a new law that was kind of developed really to consider digital technologies. And this is called the Digital Millennium Copyright Act, or DMCA. And so one of the pieces that are called anti-circumvention, which makes it illegal to create technology to circumvent technology in place to protect copyrighted work. This was an interesting development because this is kind of one of the big things around, I guess, around the 2000, late 90s, early 2000s. There was a big emphasis around putting copy protection on like DVDs. And there was a big, obviously when you put protection on DVDs, um, there was another big effort around circumventing that. So part of what was put into the DMCA is specific wording around making it illegal to um, basically overwrite, a protection on on a DVD. Now, what's happened is subsequently, technology has actually moved along even farther because we've kind of, to some degree, have moved from, using DVDs to streaming. So, it's still, the law is still in effect, but what was important, say, 17 years ago, maybe not quite as important now. A couple other pieces of DMCA that are of importance. Um, safe harbor. So it limits the liability of online service providers when somebody using services commits copyright infringement. So what happens is the if you are an online service and somebody is using your service to commit infringement, the provider of the services of the online service is not necessarily bound. It's the person committing the copyright infringement, not necessarily the online service that can be held liable for that. Um, Kind of an interesting. I said the DMCA was a challenge in a couple different areas. Like the EFF argues that DMCA limits the freedom of speech. Obviously we see around the anti-circumvention that technology changes, so things that maybe were important at one time, maybe not quite so important now. So, but it's an important, it's an important law. One you want to be aware of, and kind of what kind of what its intentions are, really to kind of take traditional um, copyright law and make it add uh, additional capabilities to be able to deal with the introduction of technology. So, Creative Commons license. What it is, it's actually an organization. Creative Commons is an organization. And what it does is it's designed to provide legal tools for artists and authors. So the idea is that it provides the ability, it gives an author an ability to control the use of the work while making it widely accessible. So basically, you're aiming to distribute, get people to use it, but you still want to maintain protection of it. So these are some guidelines. So CC BY is basically you let other people use it and build upon it, so long as the author is giving credit. CC BY SA restricts distribution of work to like a share-alike clause. So they must give credit to the original users. They must share using the same, must share it as well. CC by NC is kind of the same thing as the CC BY, but adds non-commercial restriction. And then you also have a CC BY NC ND, which is the same as the CC BY NC, but adds an ND restriction, so no derivative works can be created from the original. So it's, you just said this is really, different scenarios. The idea is really for to make sure that the author, to establish what are the guidelines and protecting the author's rights for work that is being that can be potentially be used. So a patent's been around a long time. So this is patent law kind of came into play during the 19th century. So and basically is provides protection for the inventor of a new product, including for any number of things. So you see a lot of mechanical things, um, you know, locks, plumbings, engines, business processes. Um, what it does, it gives you the rights to exclude others from making, offering for sale, or selling invention throughout the U.S. for 20 years in exchange for public disclosure of invention. Now, unlike a copyright, you have to apply for a patent. All right, and this organization in Washington D.C. patent, is basically the government patent office, which is specifically tasked with handling this stuff. patents are granted only if particular conditions are um, established. All right. Number one, it must be original. Number two, it must be non-obvious. And three, it must be useful. All right. So the invention in question has to hit these, has to be granted these three characteristics. All right. And what happens is within this, you can have patent protection for X number of years, and then it loses protection. So you see a lot of times, particularly with like in pharmaceuticals or drugs, what will happen is your patent protection goes for particular products will run for X period of time, at which point you can then be used as it becomes, other manufacturers can create the product, and it becomes, as we say, generic. It becomes a generic product. All right. So you see different, this applicability across a number of different fields. The patent troll. So kind of interesting. It's kind of an interesting thing. So really, a patent is, the patent protection is up to the patent owner to enforce. All right, so you can force somebody to use, or you can force someone to stop using it, or actually enforce or damage. So what a patent troll is somebody who will go out and will search for the illegal use of inventions, and then basically sue things that are protected under patent, and then submit lawsuits. Um, Now, what's happened is that this is sort of a not a gap, but the kind of it was kind of a situation in which patent trolls are taking advantage of kind of an obscurity, or kind of a gap in the in kind of the patent law. So what you're seeing more of is you know the these suits that are being filed by patent trolls for kind of for this can be or being held as limiting the ability to really kind of enforce that stuff. It's kind of looking at it, if it's not the original patent holder involved with this, then the cases are usually you know, dismissed or not passed through. So a trademark, it is protection of recognized branding. All right. Um, it can, trademarks are automatically issued if a word, phrase, or logo is used, is will automatically be generated if a word, phrase, or logo is being used in the normal course of business. So the common law, a common law trademark, you put a TM, next to in the title of whatever the trademark item. So you'll see that you'll see a real tiny little TM on it. Now that's the common law trademark. Now there's also a registered trademark, which is basically a formal submission of of an application. It's examined, approved, registered with the trademark office, and that has a little bit of a different um, designation. So a registered trademark office circle R as opposed to the TM. So the difference between those two. Um, Limitations on trademarks. You can't you know um, it can cause confusion. If people are putting trademarks on products, or previous applications. So you can't kind of take something, things you can't do. You can't take an existing one or try to make something similar to it that's already out there. All right. It cannot be merely descriptive of a product or service. Cannot be a geographic term. You can't, you can't trademark like the Grand Canyon or San Jose, California. Cannot be a surname, and cannot be an ornamental pattern applied to a product. All right, so these are the limitations that are associated with it. Now, PII, personally identifiable information. This is actually kind of an interesting an area which really is really come directly from the world of information technology. So there's a broad set of personal information. So what you characteristics of a person. So name, social security number in the United States, date of birth, place of birth, mother's maiden names, medical records, educational records, and organizations that are responsible for this, to deal with this and have access to it, aggregate it, have a responsibility to protect it or face penalties or loss of business. All right. So, the challenge is really to try to balance consumer protection with commerce protection. All right. So you don't want to necessarily, put burdens on organizations to be responsible for stuff, to the nth degree. But by the same token, you want to make sure there are protections people are aware of, um, you know, the material of the information that's out there. So usually what they call is an opt-out model. By default, there's an agreement to share the information unless there is a explicit direction not to. The thing that's interesting, that's in the U.S. So the thing that's interesting, if you compare that to the EU model, it flips it about. So when EU considers the information protection to outweigh interests of commerce. All right, so it's an opt-in model. You must give explicit permission for organizations to share information. All right, so the question is, which one's right, which one's wrong. There isn't. It's not quite as simple as that. It's really, and a lot of times, and particularly as technology and more information, the ability to use it continues to evolve and grow. The question becomes one of, okay, should there be a shift from an opt out to an opt in? So some of the stuff we've seen in terms of law. So a lot of this stuff is protected by laws specifically. So there's different regulatory laws that are out there. So there's a whole, depending upon what particular circumstances, what particular domain we're talking about, there'll be different sets of laws. So if you're in the healthcare industry, you're bound by what they call the Health Insurance Portability and Accountability Act, HIPAA. Education, things with schools, information by schools can come under the bounds of the Family Education Rights and Privacy Act, or FERPA. Sarbanes-Oxley is a rule that was established that any organization that is a public corporation that issues stock falls under the bounds of that. If you are in a business that takes payments through credit card, you're held under the Payment Card Industry Data Security Standard, PCI DSS, and so on and so forth. So basically, you've got a whole series of these. So these are all laws that all are, basically are, and usually they're bound by a particular area. So like HIPAA is medical, FERPA is educational, so on and so forth. Right. So these are all the. So it takes a while for a law, basically for a bill to become law and to be established. So one of the challenges, especially with technology, is the speed of technology is far faster than the development of laws. So this becomes it's one of the challenges of trying to adapt a legal framework to meet kind of new innovations and new capabilities allowed by technologies. So another interesting concept, kind of related with this PII, is what we call non-obvious relationship awareness, NORA. All right. So what NORA means is that it is the ability, which one of the things, especially with digital technologies, rise of social networking, e-commerce, the ability to gather expedite collections of personal information from numbers of sources has been really simplified. So, types of things you can gather, um, things like location. So, basically you can, where are people going? Where are they at? Where do they spend their time? Web surfing habits, criminal record, hopefully not criminal records, credit reports, what you're looking at, where you physically go, can all be tracked, in a pretty straightforward fashion using digital technology. And then, all of this information can be assembled, pulled together, and actually be used to create a profile of an individual. So the idea is if you combine what, information is on the web from Google, collect what information would be from like e-business, collect information from things like social networks, all of that together, all of a sudden this is kind of combines what we're calling NORA here. So you combine large volumes of data, information, combine and create individual profiles. The question is what you can do with that, and I think that's one of the areas I think is still being, the exact implications is something that we need to we're struggling with to try to get our heads around it, because once again the ability of technology to do this stuff is far greater than the ability to write a law to establish protections. And a lot of times people are assuming that there's laws out there, assuming they have protections, which they may or may not have. So some of the stuff we're starting to see around, there are some things out there around restriction on record collection. So some of this fits HIPAA, FERPA, um, COPPA are all have particular guidelines and restrictions around the privacy of information, so medical information, um, educational information, children's information, information about children, all have very specific guidelines which organizations have to uh, ad, uh, adhere to as they are implementing, as they are doing stuff. All right. But this is not across the board, and it's not across every industry, and it's not across every organization or type of technology. So there are some areas, but not across the board. So there's not a general across the board um, set of legislation that is in place at the current time. All right, and that pretty much wraps up our you know our um, topic area. So you can kind of review the study questions as well as the what we have in terms of some of the reflection stuff.